Score one for the little guy. Toronto-based i4i is calling its $290 million patent infringement victory against Microsoft an important step in protecting the property rights of small inventors. Here to talk about the journey they've been on, i4i Chairman Loudon Owen and founder Michael Volpe. Great to have both of you with us.
Thank you.
Gentlemen, great story, but the truth is most investors never knew who you were until today, and most think right now that you're patent trolls. People with no sales that have a patent as an asset sue everything that moves that they think is infringing on it, collect when they win. Is this your story or not?
Not. Not. Absolutely
so
not.
Explain what your company does, and does it have revenues or not, and is this how big a part of what you are today?
The patent itself is the foundation of our core technology, absolutely. Hence, the court awarded us an injunction, which the appeal court affirmed. Our customers are global companies, primarily in pharmaceuticals. In fact, I just signed a deal with Roche in Basel, Switzerland last week to install a system to manage their drug labels. And we do that for companies around the world. And we've been doing this for years.
So in terms of how long this has been going on, I mean, we've remarked on the fact that you don't take on Microsoft. It's a little bit like suing the government, right? I mean, they've got limitless pockets. You know they've got a legion of lawyers. So how long has it been going on, and is this the end of it for you?
Well, the company, to go back to the beginning, was founded in 1992 by Michael, so it's been going on a long time.
Yeah.
We realized we had an infringement potential in January of 2004. We sued in March of 2007, and we're at this second major hurdle.
Now, what is it going to take to actually collect your $290 million cash? What steps have to happen next? Because if I were Microsoft, I'd try and wait you out till you died of old age.
Well, Microsoft has already in an earlier iteration and negotiation agreed that within 15 days of any final determination they have to pay us. So they have a 15-day time period looming. And we'll see if they appeal it to the Supreme Court or not. We don't know.
And if that court hears it, doesn't necessarily get
If that
here
court hears it, that's correct.
And Mike, I want to ask you, one of the issues this raises, and it's an issue that some in tech circles in this country would say is a huge Canadian problem, and that's protection of intellectual property, that we're weak in Canada on this. If you'd fought this in Canada, I guess I'm curious to know whether you think that the laws here would have protected you as they have clearly in the U.S.
I'm not a lawyer, so I can't opine on that particular point. We certainly have excellent legal talent in intellectual property in Canada. In fact, one of our board members is a leading lawyer in intellectual property. There's no reason to believe that intellectual property protection in Canada is any weaker than it is in the United States. Clearly, for a company in our business, the United States is the market. Canada is, to be truthful, it's a very small market, and I think I have one client. I've had two clients since 1992 in Canada. Our markets are in the U.S. and in Europe, and clearly the dominant technology market in today's world is the United States, hence our patent protection in the United States.
So many of our kids use Microsoft products, including Word. Just out of interest, what functionality is it that you say they infringed on? What does it do? What does your product do that we find?
Well, I see a computer sitting here, and I'm wondering if there's infringement going on here on the air.
It's not our fault.
Feel free to sue Amanda right now.
Thank you. In Microsoft Word, Microsoft has incorporated our invention for what's called custom XML. So at the time you create a document, creating a document so that it's XML compliant, which really means taking mountains of information and being able to put it in a database where it couldn't be put in a database before.
And we had this conversation earlier, Michael, and Kevin basically said, if you're going to invent something Microsoft wants, chances are they're going to steal it from you. Is that a reality out there for small software companies that are coming up with the next greatest thing that these bigger companies just sort of swallow it?
I think there's a large grain of truth in that. The current system right now, if you look at the damages we were awarded by the court and affirmed by the appellate court, it only covers royalties that would have been due back. So there really are no disincentives to theft at this point in the system. Now, there's a lot of debate in the United States and to some extent in Canada about patent reform, and hopefully one of the things that will come out of this is that the penalties for willful infringement, which Microsoft engaged in, will actually be real penalties rather than them borrowing our money and i4i subsidizing Microsoft's continued success with Microsoft Word.
We gotta leave it there. Congratulations on this stage of your victory. May it be the last for you.
Thank you.
Thank you.
All right, Michael Volpe, Loudon Owen, i4i.